sir, what do you want to do? Because you just want to be mad at the officer.
I'm not.
No,
mad.
listen to me. You want to be mad at the officer. I would be mad at the officer too if there wasn't a valid reason, which is the only reason I went through all of this stuff. And what I'm trying to tell you is you need to just chill about it. It doesn't matter. You can sit here all day and night long and try to blame the officer for it.
Right from the start, we can feel the tension in the courtroom. This case, People versus Denante Linton, isn't just about a traffic stop, it's about a tangled web of IDs, licenses, and procedural errors. Already, the defendant is frustrated, claiming the officer overstepped while the court is trying to make sense of the records. Stay tuned because what seems like a simple stop is about to explode into a full-blown legal showdown.
Why do you want your plea withdrawn?
Just because the situation was misunderstood. As far as like the insurance and the tags, like I understand that. That's why I paid like the day of the ticket. But the officer was following me and then detained me without any questioning and was searching my car for over like 15 minutes. Then tried to get into the trunk of my car when he asked me.
Okay, that's why you want to withdraw your plea?
I'm trying to get my vehicle back because I can't afford to give $3,000 to get my car back. My car shouldn't have been towed.
Hold on a second. Okay, so your car got impounded.
Yeah.
Okay. All right. Let me just ask you this. At the time that you were pulled over, you were by yourself?
Yeah.
Okay. So, there might have been something else here, but I'll just tell you what I can see based upon paper. The offense took place and specifically I'm addressing your statement that your vehicle shouldn't have been impounded, right? So the offense or the stop, the date that you came into contact with the police took place on, I have May 14th of 2024 on Carpenter Road.
Yes, correct.
Right? Near Center Valley. So you're down by Target.
Yeah, I was down by Target in McDonald's.
Gotcha. Okay, in that. Got it. And then just looking for at about 10 o'clock in the morning, right?
Yeah, it was about 10.
Right. Well, I'm just looking at the ticket. I'm just saying what I can see. Okay, so that's on May 14th. When I'm looking at your driver's license, right?
Mm-hmm.
The information, your license, you have an enhanced license that's valid.
Yes.
Problem is, well, I don't know if it's a problem or not. I have an issue date on that of June 18th of 2024.
Of like when they gave me the new license? Is that what you asking?
Yeah, no, what I'm saying is this. I have that your license was issued June 18th of 2024. Now, my question is this. Right, your birthday's in March, right?
Yeah, March 10th.
Right. So let me just work it through here. Your original license that you received was on March 3rd of 2010.
Yes.
Right. So that license in 2010, if you get a 4-year license, so 14, 18, 22, and then it should have been 26, which means, well, it looks to me that the license prior to this one that you got in June, there wasn't one.
So I went to the Secretary of State and they told me that someone up there made an error in 2016.
In 2016?
Yeah. And then I ended up taking the driver's test twice. I don't know why someone up there made an error.
What? Right. No.
That's what,
In 2016, somebody made an error.
yes, that's what they told me at the Secretary of State. That's why it showed up on his computer that there was 2 licenses, and he said that one was suspended. And
Whoa.
no sense.
Where'd the second license go?
That's what he told me.
That there were 2.
Yes, he after he searched my car, and when I told him, he came back to the squad car. He said, "How do I get in the trunk of your car?" I told him, "You don't have probable cause for that, and or a warrant. I don't know why you need that." He went back and kept searching. Then he got in the car, and I just wasn't responding to him because he wasn't listening to me. And then he said, "Well, you have 2 driver's licenses and 1 suspended, so I'm towing your car."
Okay, so here's what. Hang on a second. I don't know anything about the search, and I get that you may be upset about that, but I'm not here to deal with that, right? He said you had 2.
Yes.
It indicates he had a state ID, expired state ID, and maybe that's where the confusion.
But it's like, what?
Hold on. The report indicates he had a state ID.
Correct. Expired at the time of the stop. And as we learned previously, you cannot have a driver's license and a state ID.
Right. So, okay, young man. When did you get the state ID? You know?
So I lost my wallet, and that one was old. That's why I went to the Secretary of State to figure that out. Because I was confused. The moment he told my
why you went to the Secretary of State when? Right after this, you mean?
Yeah.
Okay.
Right after, because I was confused. I didn't know. And then on top of that, when he stopped me, it wasn't like he was even asking me for any of that. He told me, "Get out the car or I'm going to arrest you."
Okay, look, young man, if you want to be mad at the officer, you can be mad at the officer and you can do whatever. It doesn't get me anywhere today trying to deal with your motion to withdraw your plea.
Yeah.
Okay? So you can tell me all of that. That's not going to factor into anything I have to deal with. Understood?
Yeah.
So when did you get a state ID? Do you know?
Somebody made an error. I don't know. They just this is
okay. Let me ask you this then. You got your license, because I can see it from here, in 2010. You would have had to go back on your birthday in 2014 to renew your license, because it would have been a 4-year license, right?
Mm-hmm.
If you had done that, that license should have been good to 2018. Okay, let me stop there for a minute. You're telling me that when you went to the Secretary of State, you're saying somebody said they made a mistake in 2016.
Yes. And this is the second time I've ever even been pulled over. I've never.
Well, again, I don't, that doesn't help me.
Yeah.
All right. I mean,
that's what they told me. They had to call HR, all types of stuff to try to figure it all out. And then I even had to take, I took a driver's test twice, and because they needed me to, because someone made an error up there. I got paperwork at home for 2 different.
Yeah, but that doesn't, Mr. Siller, all you can see is that the only thing he had on him was a Michigan ID.
Well, it's officer indicated that when he ran the plate, he said there was an expired state ID.
When he ran
his name, and
when he ran his name.
right, and he came back with an expired state ID and not a license, not a valid license. It's good news. He does now have a license.
No, right. And what I'm getting at is, do you know when you got that state ID?
I ended up getting robbed, and
No, I don't. I'm not.
I don't remember, because I don't have it on me.
What about the one that you I'm talking the one in May, the expired one that the officer saw.
Mm-hmm.
Do you still have that one?
No.
Okay. So whether there was a mistake or not, I can't say. All I know is this, that as Mr. Schiller was alluding to, you can't have a state ID and a license at the same time. So whenever you may have done it, when you went to get, so you would have had about, if they said 2016, and I'm guessing here, but this may make sense. You in 2016, at some point, you may have lost your license or something happened. You go to the Secretary of State because there would have been no reason for them to have contact with you from, if I just go by the beginning of your license, till 2018. But if they're telling you a mistake is made in 2016, fine. You probably need a photo ID, right? The quickest way for you to get a photo ID, well, you could have gotten your license replaced, but somehow or another, you get a Michigan ID. The moment you get that Michigan ID, your driver's license is canceled. And so now what you have is you have a Michigan ID.
This is the moment where the drama really peaks. The court is dissecting a confusing scenario. Two forms of identification, one suspended license, and an expired state ID. The tension escalates because the defendant genuinely believes he's in the right, while the officer is just following protocol. From a viewer's perspective, you can see why tempers flare. It's not every day you're told your car is being impounded over what seems like a clerical error. But here's the legal takeaway. The law prioritizes clarity and proper documentation. Question for the audience. If you were in this situation, would you trust the officer's actions or fight the impound in court? Comment below.
Right? Which is why at whatever point prior to that time that occurred, it could have occurred between 18 and 22, or it could have occurred in that period from 14 to 18. And if they're telling you 16, that's, I bet you, when it occurred. And at some point, you're operating off of a Michigan ID. And then when the officer pulls you over, all you have is an expired ID. Likely when they went in, it really isn't two licenses that he saw, because I don't see another number attached to.
Yeah, so when he said that, I was like, that doesn't make no sense.
Well, it does, but it's not a license he's looking at. He's looking at what he sees are two forms of ID. He's seeing your Michigan ID when he's running it. He's seeing your Michigan ID and he's seeing a license. It can't have both.
Okay.
And so if that's what the officer saw, I can understand his suspicion then, because you shouldn't be able, you can't have two of them. Whether somebody made a mistake or not, it's the Secretary of State, I don't know. I'm just saying you can't have both. So then after this stop occurs, you go to the Secretary of State. They're going to make you, you're over 18, so they're going to make you basically start again, because at some point, that's why you took the driver's test course, because at some point, your license lapsed for an excessive period of time.
Okay.
And that's going to be the period at which, whenever it was, that you had the Michigan ID.
Mm-hmm.
That's what happened. That's why you become the focal point. Now, it makes sense with what, it may not make sense to you when you're there, and you may think the officer's not telling you something, but I can understand it now, because you have two forms of ID. And the only one he finds on you, or that you have, is the expired Michigan ID. But you had said you lost your wallet or somebody took your wallet. So you don't even have your new Michigan ID on you.
They just gave me a new one now though, but
What?
they just gave me a new one now.
When? In June?
I got it in my pocket.
No, but that's different. Okay. I'm having to deal with this way too much in my life. That's different than what the officer had you with. The expired one, what he had you with was an expired Michigan ID. That's different than having a driver's license. That may be that I don't know why you're there in 16, but if something happened to your driver's license in 2016, you go to the Secretary of State. What you want is your license back. And when they're telling you somebody made a mistake, I can't say it's happened. Whatever happens, you get a Michigan ID. That cancels your driver's license.
Okay, I understand that.
You following me?
Yeah, I'm following.
And then as you're just kind of moving along, living your life, doing whatever, at some point, and just looking at it from the Secretary of State side, your license, you just lapsed. It's like you went in and said, I don't want my license, give me a state ID, is how they're going to see it, regardless of what happened when you were down there at the Secretary of State. And then that period in time lasted so long that then after this happens, you go back in, you got to basically start again. Make sense? I mean, that make you happy?
Oh, no, that does. No, I understand now.
And maybe so that you can sort of understand from the officer's perspective, okay, because you were bringing this up, and maybe to chill you out a little bit. The officer, when they run you, I now get two things. You don't have anything on you except an expired one, right? But I now get two things that come back on you. The only thing you can show, I don't want to say it, but I'm trying to make it really clear because I think this is what happened when he told you had two. If I'm the officer, I'm not sure that you ever got a driver's license. Okay, and I'm guessing a little bit, but it makes sense. Because I see two things come up, right? And the numbers are going to be similar, but I see two things come up. And the only thing I've got on you physically is an expired ID, which then leads me to the conclusion that you didn't have a driver's license. But for whatever reason, a driver's license is coming back, but that driver's license is gone. Yeah. Follow me?
Mm-hmm.
Now, at that point, and I'm going to tell you, even if it were me on the road and I stop you and all of that comes back to me, I'm suspicious of you at that point because those things shouldn't be happening. Right?
Mm-hmm.
And it would have almost been, and this sounds crazy, but sometimes life's, it would have almost been better if you hadn't had the expired Michigan ID. Right? Because at that point, I could almost say there's got to be a mistake somewhere. But the moment you had the Michigan ID, I think you just have a Michigan ID that you didn't have a driver's license, but somehow another driver's license showed. Okay? That's why he probably has the suspicion of what the heck's going on.
So,
I mean, I'm not saying it's your fault, but what I'm saying is I don't think it's the officer's fault necessarily either, the raising of the suspicion. Whatever happened is they're telling you in 2016, mm-hmm. This was just waiting to occur at some point.
Okay.
It was just going to happen. And you
So whether
probably
he did-
you probably walked out of there thinking that you had a driver's license when really all you had was a state ID wherever that got messed up.
So whether he did that, but he did all that after.
Did all what after?
Like, why didn't he run my plate?
No,
run.
he knows before he's gonna say anything to you. I'm telling you right now.
No, he didn't run my plate still until after.
Not the plate, the
He didn't-
license.
Even that, he didn't look at none of that until like 20 minutes after.
So he does that before he goes over the.
Goes over.
What you mean?
Oh yeah, he knows
He has all the information before he stops.
before he.
You know how I
I'm
know he didn't?
Look, young man, you can sit here and argue with me.
I
I'm gonna tell you what. Do a ride along. You will see. They know it before they necessarily.
I'm asking you how. I'm asking you how. Because how he gonna run my plates when I have a cover over my plate? My Audi is custom.
It doesn't.
When I put it out,
Sir, what do you want to do? Because you just want to be mad at the officer.
I'm not
for something.
mad. I'm
And
not
no,
mad.
listen to me. You want to be mad at the officer. I would be mad at the officer too if there wasn't a valid reason, which is the only reason I went through all of this stuff. And what I'm trying to tell you is you need to just chill about it. It doesn't matter. You can sit here all day and night long and try to blame the officer for it. Because the first question I asked you is I said, were you alone? And the reason I asked you if you were alone is because the moment you don't have a license, he can't leave that vehicle. That's why your vehicle's impounded, because that's the first thing you came to me and said. So if you want to argue, you can go argue elsewhere. I'm here to just deal with your motion.
I'm not mad or frustrated. I'm saying he couldn't have ran my plates.
Yes, he could.
How are you gonna run a plate when the plate got a cover on it? He can see through the new plates that you can cover up. Like, that's what I'm trying to ask. That's what I'm not understanding. When I pulled off on Carpenter, he was coming from textile.
And you're saying your plate isn't exposed on your vehicle?
My plate, it's the new plates that you can order. So it can be exposed when I allow it to be. I just picked the car up. The car has been in the shop for months. I haven't driven my car all year. When I pulled off on textile, he just can't, he was following me.
Okay. He's just a bad officer. You know what? Go ahead, sue him.
Have
your day in court.
That's what I'll do.
You go ahead and do it, but don't do it here because I don't have any more time to listen to you. I'm trying to explain it to you, but you want to be hard-headed and not do it. You want to say, how does he know? I'm telling you, before they walk up to that vehicle, they know who you are. Just as simple as that. You may not like it. Everybody else may not like it. That's too bad.
Ultimately, the judge walks everyone through the critical timeline, the expired Michigan ID, the suspension history, and why the officer acted as he did. While the defendant feels wronged, the court's decision shows that procedures exist for a reason. Even small errors in paperwork can lead to serious consequences like impoundment. This case is a perfect example of how attention to detail and understanding legal obligations are crucial. If you found this case as shocking as we did, make sure to hit that like button. Share your thoughts in the comments. And don't forget to subscribe for more jaw-dropping courtroom breakdowns.
Okay.
They lost my rent. I'm trying to stay calm, sir, but I am so upset because I have never went without paying the rent.
Now this is where the case takes a dramatic turn. We're not just dealing with lost rent anymore. We're looking at altered money orders, whiteout marks, and a roofing company listed as a payee. That raises major red flags. From a legal standpoint, if the money orders were altered after purchase, that leans toward fraud by an unknown third party, not the tenant or the landlord. Judge Simpson is carefully trying to balance both sides here, acknowledging the tenant's frustration, recognizing the landlord never received payment, and still maintaining courtroom order as tempers flare. The judge's calm explanations show how courts separate intent from outcome. But I want to hear your thoughts. Does this look like internal mismanagement, a clerical mistake, or something more serious? Drop your take below because this situation is starting to look suspicious.
Woods versus Artelia Reeves.
Lacey Madsen, P87729 on behalf of the plaintiff.
Hello, sir.
Hello.
How are you?
I'm doing just lovely. Thank you for asking. How are you? All right. And also Dorothy Williams. All right. So last time we were here, there was $1,066.69. How much is owing at this point?
Your Honor, I have rents to retain of $856.64. Cost of $240 for a total of $1,096.64.
Yeah, went up a little bit. All right. How are we going to get this paid off?
It's already paid, sir. They lost it.
Okay.
They lost my rent.
Hold on.
I have receipts. I gave them receipts. She took a photocopy of it.
Who?
The lady that was up there in the rent office. Her name was Dana. We don't have management because everyone has quit. And my rent came up missing, and the woman that was there, she quit or got fired. Now,
okay. All right. Are you going to have your January rent?
Yes.
Okay. When are you going to pay your January rent?
On the 3rd.
Okay. Then here's what I'm going to do. What's your monthly rent?
$657 plus the water bill. My mother is 94 years old.
Yes, I recall, ma'am, the last time you were here.
I'm trying to stay calm, sir, but I am so upset because I have never went without paying the rent. And here these people got me up in here defending myself, and I got receipts, a bag of receipts, a bag.
So you pay your 657 plus whatever your other charges are. You're to pay that by January 3rd, 2025.
Yes.
Okay.
Yes, I pay it every
that rent. So this way the number doesn't get worse. So everything is done, and then we can try to figure out where we go from here on this. I'll adjourn this then to January 10th, 2025 at 3 p.m. Hello.
3 p.m.
Okay, at 3 p.m. Okay.
Yes,
and
sir.
we'll figure it out in terms of what was lost and when it was lost and anything along those lines. Okay.
Yeah. And can I say something? They told me that I had to run this thing down. I called MoneyGram. MoneyGram said that one money order was cashed on the 7th. Another one was cashed on the 8th. What the heck? What the heck?
Okay.
And then you're going to send me papers talking about find it? You find it. I told them, you lost it. You find it. Doggone they time. I'm not happy. I'm not happy. My mother is 94 years old. She has a colostomy bag on one side and a tube in her gallbladder on the other side. We cannot afford not to pay our rent. She's 94.
Ma'am.
Doggone they time.
Ma'am.
Yes. Yes, sir.
What I need you to do is, if you got confirmation that those were cash, I need you to get written confirmation from MoneyGram that has happened. Bring that to the next hearing.
Okay.
Because that's going to be important for us trying to figure out what happened.
Okay.
Okay.
Okay, sir.
All right.
Happy New Year, Judge Simpson.
Yes, ma'am. Thank you.
And Happy New Year to everybody.
Your Honor,
Yes, ma'am.
is that amount to be paid for both this matter and the past matter to my client, or are we putting that in escrow with the court?
She's going to pay it to your client. She's gone, but that's where I'm sure she's going to pay it because
Okay.
your
Thank
client's going to have to hear it. Okay. And Dorothy Williams.
Hello, sir.
Hello.
How are you?
I don't know yet. You're gonna. Well, I don't know because you look like you're gonna yell at me.
No, I'm not. My mother told me to calm down before I have a stroke.
And she said, "Calm down when you come before me," didn't she? I like your mother.
She told me.
Because the last couple of times.
Oh, but you know what, Judge Simpson?
Yes, ma'am.
I have so much on my plate and I know what I've done. And when you know what you've done and someone is trying to tell you you didn't do it, I'm like, But here it is. Would you give this to Judge Simpson, please?
Are you just gonna do what she says? I know, I was scared. No, I got you. Okay, what am I looking at?
You're looking at the receipts that I was telling, the money orders that I bought for the rent for October. And all this time I was telling you, someone up in that office took my money orders.
Okay.
I'm trying to.
No, right now you're not listening to what
Okay.
your mama told you, right? Right?
Yeah.
Okay. Okay. And you have not shown this to counsel?
No, I didn't show it to anyone, but my mom and you. And you see where it looked like they whited out? You know, Susanna Vera, who is she? Who is she?
Who?
Susanna Vera. If you see on one of those money orders
I do.
that says Susanna Vera, I don't know who she is. And on the other money order, it was made out, crossed everything out, and made out to a roofing company. I don't know nothing about no roofing company. I don't.
So with these money orders, you're saying you put them into?
I put them, I done, if I didn't have time because we don't even know when the office is open anymore. I know, but you know what, sir?
Musa,
Okay,
take it down.
okay.
You are not going to make it through this hearing without. If you need to yell at me. I can take it.
No,
Just go ahead and yell at me. People
Well-
do all day.
well,
Doesn't bother me. I take the robe off, go home. I'm fine.
oh no. But what I'm trying to say, sir, if you look at it, both of them, it seems like somebody whited out. I'm shutting up.
You're not telling me the truth on that. Because you're going to say so. You're just going to be quiet for right now.
Be quiet.
Okay. All right.
Turn my head. Be quiet.
Ms. Dornbush, I don't. You haven't seen these, and
I have not, Your Honor, and just giving Ms. Reeves the benefit of not seeing them, and that what she's brought to the court is what I think it is. I don't think there's any dispute that Ms. Reeves purchased money orders, but even based on that, there's also no dispute that my client didn't receive that money either. And so I know there's a process.
I absolutely agree with you on both those points, unless, and I don't want to.
What's the name of the roofing company, Your Honor? I do not know a Susanna Vera at the Arbor Woods office. I do not believe that individual is an employee there.
It says LLB Soffit and Gutter Seals, maybe, or.
And Your Honor, if the court's able to scan those over to me, I'm happy to review those.
Yeah, we will. I was going to do that.
In the interim, I know MoneyGram has a procedure for Ms. Reeves to dispute that the payee is the intended payee and to request that they be reissued to the intended payee. And I don't necessarily.
Welcome back to the courtroom, where missing money orders turn into full-blown investigations and frustration hits the boiling point. Today's case revolves around a tenant who insists she paid her rent with receipts to prove it. But the apartment office claims they never received a single dollar. And as we'll see, these money orders didn't just disappear. They were allegedly altered, white out and all, before ending up cashed by people the tenant doesn't even know. With a 94-year-old mother depending on her, emotions are sky high, accusations are flying, and Judge Simpson is trying to navigate through the chaos with patience, humor, and some well-timed reality checks. Who's at fault? Where did the rent really go? And why does it feel like this office is being run by ghosts? Stick around because this one gets messy fast.
I have an objection to continuing this court case and having her pay the ongoing charges while those disputed amounts are hopefully reissued by MoneyGram.
Yeah, I don't know if they're
The problem is the last paragraph and you'll see it when it says that they're saying after the purchase of the money order, MoneyGram is not responsible for the acts of purchaser fees and others which may result in a dispute. Confirmation of a cash.
And I think that's for the intended payee. You know, if there's a dispute between the purchaser of the money order, Ms. Reeves, and her intended payee, Arbor Woods. But here, those individuals that cashed those money orders were not her intended payee. Ms. Reeves was certainly not.
No, I agree with you.
Or the roofing company.
Well, I'll let you read it. I read what they're trying to say a little bit differently. I thought she was going to be quiet. No, go ahead.
Because, sir, she keeps saying that I purchased these money orders.
Hold on. Let me stop you.
Okay.
Okay. Ms. Dornbush is representing her client.
Yeah.
She's not trying to make an accusation necessarily against you. What she said at the very beginning is absolutely true, and it's something I agree with. I believe that both things can be true here. I think you dropped these off. Somebody got them, right? So what you tried to do didn't happen. What the landlord wants is everything paid. That didn't happen. That's really all she's saying. They didn't get the money and it didn't go to your account. Okay? All right. Did that calm you down at all?
No.
Okay. That's all I got. Can we scan those?
Because
yes, ma'am.
if you look at it, it looked like someone whited out.
No, I see what you're saying. The problem is, I don't know. You may be saying that it may be somebody that's affiliated with the landlord.
It is.
Who?
I can't say her name because she was the only one working up in the office. Here I am.
Okay.
I've been putting
hold on.
Your Honor, if Miss Reeves has a belief on who it is, I would request that she provide me that information so I can discuss it with my client. But as of now, I have no reason to believe that an Arbor Woods employee took her money.
She doesn't even work there no more. Her name is Zoe.
Okay, hold on. Just here's what I want you to do.
What?
Okay. First thing I want you to do is you got to take your mother's advice. You need to calm down. Seriously.
I'm about to have a heart attack.
Yeah, I know. But that's what you're doing because you need to calm down. There's not much that can be resolved. I'm going to put this over a week. What I want you to do so that somebody's name isn't out there, I want you to call Ms. Dornbush's office.
Call whose office?
The
This
attorney's
lady's office?
Yes.
I don't have her number.
Okay, it's on your paperwork. We'll get you a number.
Thank you.
Call her.
Yeah.
And ma'am, I'm just gonna say this. She's willing to take the name. She may not be able to get to an answer.
Mm-hmm.
Okay. Even after she talks to her client, she may not be able to get to an answer. But one of the things that I expect from all people is that you treat people with respect.
Yeah.
So when you call her, I don't want any of this.
Yeah.
If I get a report of any of this, I am not going to be happy.
I know.
She wants to take that. She doesn't even have to do that.
No, she doesn't.
She is offered to do that so she can talk it over with her clients
Okay.
about it. Okay.
Okay.
So you treat her right.
I will.
And I know that she will treat you right.
I will.
Okay. Yeah, that doesn't mean the people have to disagree.
Yeah. Can I say something else?
I cannot stop you. I haven't been able to stop you yet. Yeah, go ahead.
If you look at my pay log, I have never been late for my rent.
That is about the 20th time you have told me that.
I know.
Between the times you've been here.
I know.
Everybody can see that.
Okay, Judge Simpson. My mama told me to just behave myself in here today.
And do you think you did that?
Yeah.
No.
Okay.
January 31st, 2025. What time? 1 p.m.
1 p.m. Okay.
I'll be waiting with bells on.
Okay.
All right.
Okay. Am I gonna leave those papers here?
Oh, did you make me a copy? Or did you give me back?
I gave
you back the original, but I have scanned the copy. I can print and file.
Okay. Let's get those back.
Thank you. I'm nervous.
You're nervous?
Yeah.
I couldn't tell. All right. You have a good weekend.
You too, Judge Simpson. And I look forward to seeing you on the 31st.
Yes, ma'am. Arborwoods versus Reeves. And Dorothy Williams.
Good afternoon, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
Boy. State your name, ma'am.
My name is Artelia Reed, Judge Simpson.
Yes, ma'am. All right. Okay, where are we on this case?
Your Honor, if I may,
Yes.
Ms. Reeves, I believe, spoke with Ms. Dornbush from my office yesterday. Unfortunately, there has not been a resolution on this case right now. We have been in communication with our client to see if there is a way for us to resolve this. Unfortunately, we haven't heard anything back. So right now we are requesting that this be set for a bench trial because I don't think we're going to be able to, we haven't been able to resolve it. Yeah.
Yes, ma'am.
I feel like I'm in a twilight zone. I'm just going round and around, and I'm not.
Okay, that's my everyday. So go ahead. What?
I feel like I'm in the twilight zone.
Why?
I talked to Attorney Rachel yesterday.
Yes, Ms. Dornbush.
And she's saying, okay, she works for Arborwoods, and Arborwoods is paying her to collect some money out of me. And I'm telling her that I paid it. I paid it. I bought all types of proof. Somebody wiped my name out up there in that office, but I did tell Attorney Rachel yesterday that I will call MoneyGram again.
Okay.
And see if I can, if I get in contact with the fraud department, see if they can replace this. Because I paid, and now I got to prove that I paid. And
okay, I understand. So here's what I'm going to do. I'm going to set it for trial. I'm going to set it for February 18th. So that gives you some time to do that. You're going to pay your February rent to the landlord. I just ask.
Yes, sir.
I know
I'm
that you
going
will.
to pay
All right.
February rent. You know what, Judge Simpson? Yeah. I just rather look at you on TV. I don't want to be looking at you every week, every month. Oh my goodness.
Why? I look better on TV?
Yeah.
Yes?
Yeah, I'm on TV.
Wow.
Yeah.
That kind of hurts, doesn't it?
So come back on the 18th?
Yeah.
At what time?
It'll be at 9 a.m. It'll be for a trial, but it'll give you time to get the information. What we're hoping is you can get that information from them. Mm-hmm. And then if it can't be resolved, then I'll hear testimony and I'll resolve it. Okay.
Okay, sir.
Fair enough. So you got to come back and see me.
I got to come back and see you. I knew I was going to have to come back. Have a good evening.
And that wraps up this whirlwind of missed payments, disputed money orders, and a tenant who refuses to back down. Across 3 hearings, Judge Simpson tried to untangle a complicated situation where both sides were telling the truth. The tenant did buy the money orders, but the landlord never received a cent. Now the court heads toward a bench trial, where the judge will review evidence, compare signatures, and ultimately decide who is responsible and who should absorb the financial loss. Cases like this remind us how crucial proper documentation is. especially when working with money orders or unstable management offices. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more geo-dropping courtroom breakdowns.
I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out. That's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel.
Well, that's called the case of the people, state of Michigan versus Cyrus Abadi.
Good afternoon, Your Honor. Raise hand. Assistant District Attorney.
And good
People.
And good afternoon, Your Honor. With also on behalf of Cyrus Abadi, standing to my right. Cyrus, please speak.
Good afternoon, Your Honor. Cyrus Bobby here.
All right, this has come back to me. I don't know if it's really a motion, but I don't know who would like to start. But I certainly have some questions.
A few things to put on the record. I'll defer to Mr. Dowse if he wants to go first. I have no problem with that.
I do not need to go first. So.
Well, you might need to. I'm going to let you put on what you need to put on the record, because I think the last communication I saw, Mr. Dowse had filed something and you had requested whether or not we needed a written response or whether or not you could give an oral response. I think my staff had indicated what my answer was and that you could give an oral response on the record. So if that's where you'd like to start, go ahead.
That's correct, Your Honor, and thank you for the opportunity to do so. I actually don't know where to start. This is a unique situation. I've never been accused in a public filing of lying. I've never been told that my narrative is sanctionable. So I'm not sure exactly where to start. I will start.
Well, I've got some things to say about that, but go ahead. Because and Mr. Dawes, I'm just going to tell you, I don't expect attorneys to necessarily like each other. I don't even care whether they like each other. Whether they talk to each other is irrelevant to me unless they cannot communicate in some professional way. But as I've told other attorneys, and particularly, and I'll name him Mr. Bennett, when he came and he accused somebody of some type of misconduct, that when that statement is made, the court has to look at that. And so I made it very clear to him, and I'll make it clear to you. If those are the kinds of things that are going to happen, you better be ready to roll with it, and you better have it. Because if you don't, that's sanction. Ms. Tanner, you may proceed.
Your Honor, as counsel knows, and I think everyone in this room is aware, within this profession, our reputation.
The prosecutor emphasizes her experience and integrity, explaining that she has made tough decisions and defended opposing counsel when needed. This isn't just ego, it's strategy and credibility. She makes a strong point. Baseless accusations can't be tolerated. She's calm but firm, showing that in law, your professional reputation is like gold. Every statement, every accusation is weighed heavily. For viewers, this is a textbook example of how lawyers defend not just their client, but also themselves, all while staying within the bounds of the courtroom.
And our integrity is everything. Throughout my career, I've routinely made decisions that were difficult decisions to make in a lot of aspects. I've been able to make those decisions because my reputation and my integrity are that important to me. Quite frankly, no case is worth me losing everything I've worked so hard for. What I've also routinely done in front of Your Honor, as well as other judges, is stand up here and make a point of defending opposing counsels when other people have accused them of anything from lying to misconduct and so on. The reason I make a point of doing that, even though in many situations that has truly not been necessary, is because I want to be very clear how important it is that we don't throw out baseless accusations at people. It's not a new situation to me necessarily to encounter a situation with opposing counsel where we disagree, where we misunderstand each other. I don't take offense. I've gone head to head with some of the best attorneys in this county as well as other counties. And not once have I been accused of what defense counsel is accusing me of. And what bothers me more is I actually started out respecting defense counsel a great deal. As far as I knew, we had a fine working relationship, and I had no reason to believe that anything changed. I think I in this situation, have been more patient, respectful, and understanding of this defense counsel than I would have been with a lot of other counsel for that reason, because we started out respecting each other. Obviously, we've had a point where that's changed. I'm not sure exactly why, and maybe counsel will enlighten us today, but he seems to have a personal problem. I am perfectly fine arguing law. I'm perfectly fine arguing procedure. I am not fine with personal attacks. Those personal attacks are not just in the written form in these public filings where I'm being accused of all kinds of things. They've also been verbal. They've also been contained in an email communication. I have an email, and quite frankly, Your Honor, I wasn't going to bring this up because I don't take personal offense. This field makes us develop very thick skin, and I don't anticipate in dealing with other people within this field for them to have thinner skin than I do. And perhaps that is my mistake, and I need to be more cautious and aware of people's hurt feelings and how it affects how they conduct themselves. I do want to put this on the record because I think it speaks to why we saw the reply that we saw. This is an email from September 25th of this year from Mr. Dust to myself. It's in response to a request he made, a reply I sent him, which again, we can certainly look at that, but this is the part I'm not concerned about. Curious, you can articulate and posture all you want, Marie. Just don't think for a second that I'm not seeing right through you. I don't know what the intent of that email was. What I do know, it's not necessary for what was being discussed. What I know is that it's a personal attack. So I'll just leave it at that. I'll leave it at that. It's not lost on me that unfortunately we live in a society where people who are privileged in certain ways, and specifically being male, think that they can address female attorneys a certain way that differs from how they would address male attorneys. I do this job not expecting to be treated any differently than my male colleagues. I advocate just as strongly as my male colleagues do. Anything less than that would be ineffective. What I don't expect is to get the treatment I'm getting right now from defense counsel based on being female. And that's exactly, I'm just going to call it out, that's exactly what it is. I highly doubt that any of my male colleagues from our office would have been treated the way I've been treated by defense counsel. And even though I probably shouldn't be shocked at this point, having done this job as long as I have, I truly am. Because in working with many different male, female counsels of all backgrounds, this is the first time it's risen to this level. And that's saying something. What's even more concerning to me is that it was done in a public filing. Now, I realize, and I've come to understand that defense counsel's feelings were hurt by what he seems to believe is attitude for me or my treatment of him. I have not treated him any differently than I would treat any other counsel. I've conducted myself in a professional manner when I could. There are times where we have very intense discussions, and that's not out of any kind of intent to offend anyone. I'm quite shocked that defense counsel is as offended as he is by me and the job I've been doing. I was also shocked to read what he wrote. My hope is, because I try to get—
Are you talking about what, and I don't mean to interrupt you, but you're talking about what he wrote in his response?
In the reply, specifically in paragraph 5.
The tension continues as the judge and opposing counsel weigh in. The prosecutor calmly insists her behavior has been professional and measured, despite the defense's claims. Here we see a critical courtroom principle: tone and intent matter. The judge acknowledges her long-standing credibility and experience, signaling that professionalism isn't just about procedure, it's about consistently demonstrating integrity. For the audience, this is a fascinating glimpse into how judges parse intent, respect, and precedent before making decisions.
My hope is that counsel's kind of passions and hurt feelings took over, and that logic and common sense just didn't catch up quick enough before he filed that reply. So with the court's permission, I'd like to offer him an opportunity to essentially withdraw paragraph 5 of his reply and ask the court to strike it from the public record. I think that's the appropriate thing to do. I'm not going to sit here and ask for an apology, but at the very least, that is what he could do to remedy the situation. And I do have serious concerns about his ability to efficiently represent his client when he seems to have such hurt feelings and such a personal problem with him. So that might be something he might want to consider. And you're not going to discuss the case. That's something I appreciate the opportunity to put that on the record. I felt the need to defend myself. Judge Barr was present for a great deal of our conversation, actually all of our conversation in chambers. And I'll kind of leave it at that.
As to that issue, and I great hesitation in saying this, and certainly Mr. Duss, you can respond if you want to that. When let me just say this before you respond. I've read over the years a number of your pleadings, both from you and both from those in your office. I'm trying to be careful in the way that I put this. What I read when I received that, I was surprised. Surprised, and I will say a little bit taken aback. Mainly because, and you know me, I'll just be blunt, I expected better from you. So, and I say that not with any thought as to how I would rule on this issue, because that wasn't really what was playing into my mind. Just expected better. Go ahead, Mr. Dobbs.
Thank you. This is not personal, Judge. This is professional.
Which
part? What I have put in writing and submitted to the court.
No, Mr. Doss. And I'll let you go on. But no, this was clearly personal. I have been reading briefs and preparing briefs, memorandums for over 30 some odd years. I've been reading them as a judge for over a quarter century. If I say to an attorney that I'm taken back by what you put in and that I expected better, you can take that however you will. You can defend yourself. You can say I'm all wrong, that I'm washed up, that somehow or another you can say whatever you want. But I don't say it unless I mean it.
Understood.
Go ahead.
Well, I'm an honest man. Ms. Tanner is quite skilled at doing one thing and then portraying it as something else. On September 23rd in chambers with Judge Bauer, she brought up a legal issue for which there is no support, no authority. We sought to have a conversation about that, and there was no conversation to be had with Ms. Tanner. And so the exam ended up being adjourned because Judge Bauer at the moment was not in a position to decide any of this. The legal issue before the court is, there's no dispute that preliminary examinations are governed by statutes, court rules, and the Michigan Rules of Evidence. And under those rules, under MRE 404A2C, defense counsel at exam at a CSC case may inquire about what is permitted within those rules. The proposition before the court is raised at the last occasion is that for defense counsel to elicit evidence under that rule at exam, there first has to be a motion and offer of proof. For that proposition, there's no authority whatsoever.
Okay, Mr. Doss, can I just stop you since you want to get into the substance of it? Let me just say, all the years I've been sitting on the bench, the rape shield statute has applied at preliminary examination. Because if it didn't, it frankly makes no sense. Say to someone, we afford you these protections from this intrusion into your life here, but we don't do it here, makes no sense. Because it's one of those things that once the cow has left the field, it's out. It's just there. And so it doesn't make any sense. Moreover, Mr. Doss, I was a bit surprised by it because your colleague, Mr. Shea, has argued the rape shield at preliminary examination, I believe on 2 occasions, but certainly one before me, and never indicated, never said whatsoever that it does not apply at preliminary examination. Go ahead.
Well, the authority.
The key question emerges. Does defense counsel need a written motion and offer of proof to question evidence under Rule 404A, 2C? The court confirms that no, it's not required at this stage. This moment is pivotal because it clarifies the scope of preliminary examinations and protects victims under rape shield statutes. For anyone watching, this is where legal technicalities directly affect trial strategy. Every word here is carefully chosen. One misstep could alter what evidence is admissible later. This is law in action, live and unscripted.
That issue is to the contrary. I believe it. I put it in writing. I provided the court with the authority. What in fact I did was I did not submit an advocacy piece. I did not. I'm not asking anything of the court. I'm not trying to convince the court of anything. I advised the court on what the law is. I believe I was well within the rules on going about it in that way. As far as now what Ms. Tanner put on the record earlier, I understood, based on what the law is, that Ms. Tanner on September 23rd was taking an unsupported legal position and was in a way misinforming Judge Barr about it and was not having a conversation about it.
What, misinforming Judge Barr that the rape shield applied at preliminary examination?
Yes.
She would be taking a position that has been the longstanding practice in this county. How can you say that she's somehow just come out with something out of thin air? Show me one case, Mr. Dawson, in this county where rape shield has not been applied and not stood at preliminary examination.
The aspect that doesn't apply is the mechanism of a motion and offer of proof in MCL 750520J2. That aspect is just not applicable at this stage. It comes into play once the case is bound over. And that's the very issue that Ms. Tanner raised. She approached me asking whether I would elicit any testimony.
So, Mr. Das, you paint yourself into a corner because if that's the argument, then none of it comes out at prelim. Because the judge at prelim is the gatekeeper of all of that. And so what would actually end up happening is none of it would come in ever. And then you go ahead and just make your argument in, circuit court.
Well, I understand we disagree on what the applicable law is on the issue. I did put it in writing, it is published.
But I'm talking about two different things, Mr. Das. I'm saying if you're indicating that the doctrine of rape shield and the protections that it's afford do not apply at prelim, then the judge, quite frankly, has the option of not hearing that testimony. Plain and simple. And then I just don't let it in. If I'm handling it, I don't let it in. And then you're going to have to deal with it as you want to deal with it in circuit court, which you won't get it in there.
If what the court describes were so, then the court would at that moment disallow the admission of relevant evidence under the court rules.
It's irrelevant. Somebody's past sexual history is irrelevant. I could just say that and I'm done.
Not with the defendant.
Pardon?
That's what the law said. That's what the court rule says, not with the defendant. That is not what the rule says. So, if I can go back once more. The very core item that's at issue is whether defense counsel, before exam, needs to provide a written motion and offer of proof if defense counsel wishes to inquire into evidence under 404A2C. And the law on that is that no, defense counsel is not required to do that. Defense counsel may inquire under the rule.
Okay.
Okay.
And if the judge says, I need a motion before you do it, what do you then answer?
I would ask the judge, what is the legal basis for making that requirement?
And the judge is going to say, because I said so.
I am hearing that, and yes, I am greatly at odds with it, because there's no legal basis.
Maybe that's the
for that
reason
requirement.
you wear the robe and you don't.
All right. I did submit in writing what I know the law to be, and stand by that.
Anything additional, Mr.
At this point,
Right. This court is ready to rule so that there's an order that fashion Judge Barr can deal with. And that is that this court indeed does believe that the rape shield statutes were intended to offer certain protections to potential victims. That evidence, and this specifically needs to be noted, that evidence shall not be elicited at preliminary examination in any greater or lesser fashion, but in the same manner as that evidence would be alluded to at trial. To do otherwise would make the rape shield a nullity in its entirety. And so therefore, that evidence will not be allowed until such time as the court has had an opportunity to see what evidence is proffered at preliminary examination, is going to be proffered at preliminary examination. Tana, you will prepare the order. I will sign off,